Hello, everyone. Welcome to LexTalk World Talk Show presented by ClickAway Creators. Today, we have Mr. Ajay Monga with us. Mr. Monga is currently a partner at SNG Partners. He started his career as an individual lawyer on the civil side before joining the firm in November 2001. Um, Possessed with experience of over 2 decades in litigation, he has advised and represented clients in a wide area, areas such as banking, corporate law, HR, international trade and finance, and foreign exchange, and money laundering, and so on and so forth. And he appears regularly before Supreme Court of India, Honorable High Courts, and various tribunals constituted under various laws. We have a lot to discuss about him today. Without further ado, let's welcome him. Hello, Mr. Monga. How are you doing?
Hi, Sagar. I'm good. Thank you.
Great, great to hear that. And thank you very much for joining us for the session. It's really our pleasure. As I said, I tried my level best to cover things about you in few words that I had. But let's dwell down to your practice. And my first question would be about a case of yours. So if you can tell us about a complex legal issue you worked upon recently or in past, and if you can also describe the complexity around it, and of course how you approached it.
All right. So see, as a lawyer, you come across various diverse issues every time you are faced with a new case. The client will, give you a distinct fact which you would not have imagined that these kind of facts also exist in the world. So yes, recently I would not say it was a case, though there have been various litigating cases. But recently I came across advisory matter by a banking client. So in a nutshell, I can say that the client wanted to repatriate certain funds for the import of goods, and they came to us saying that whether they can repatriate the funds to a foreign land. The import of goods was intangible goods, so it was not a physical delivery of goods from a foreign land to India, and all these things involved foreign exchanges, because the moment the bank is transferring funds outside, there is an element of foreign exchange going out. So when we understood the facts of the matter, so it was, these days we all use mobile apps for gaming devices. So it was a gaming company in India who had developed an app which has a lot of games in it for mobile application. And one of such games had a distinct coin kind of a thing. Like we all use some coins in the gaming app to purchase certain things, which is helpful in the games. And those particular coins, or the codes of those coins, or the programming of those coins, was done by a foreign entity in outside India. So this entity in India was to import those coins to integrate with the gaming app. And in respect of those import of intangible so-called coins, the money was to go out on a regular daily basis. Daily basis, subscribers were playing games, the coins were being used, and the coins used to be uploaded or downloaded by this customer of the bank on the gaming app. So the question was whether there is any goods in place, whether the imports are happening, how to satisfy that yes, certain goods have actually arrived in India, though it's electronic goods, and what precautions should this banking client take to ensure that the FEMA regulations are complied with. So we had a lot of brainstorming with the client to understand these facts. We had to look into the FEMA laws. We have to look into the RBA circulars. We have to look into the Gambling Act to ensure that the game for which these coins are being used amounts to gambling, or it's a skill-based game. And to understand whether it's a skill-based game or a gambling, we have to go to the Supreme Court judgments. So it was complex in some way, because we had, at least I had no prior experience to figure out whether an import of intangible goods and what kind of documentation is to be taken. Then the RBA circular is there, which mandates certain documents to be taken by the banking institution. So what are those documents, how those documents are to be worded, whether the documents taken by the client are sufficient enough to satisfy itself that the import of goods has taken place. The coins, so-called coins, have been downloaded. So yes, so this kind of a application and the facts were very complicated for us. And 2, 3 circulars, acts, different, enactments of FEMA. So that makes the entire thing very complex. So it was good experience to give an opinion ultimately to, yes, you can repatriate, and those goods are imported.
I mean, as you stated before answering the question, that there are some facts that you don't even know that these facts exist is, I guess, a great example. I have never heard a case something like this. I've had so many interviews so far, but thank you very much for sharing that. Uh, I also wanted to talk about or touch base on the last few years that we all should just survived the pandemic time.
Yeah.
And we saw, I mean, from your standpoint, from the legal industry standpoint, the
Yes.
pandemic saw some courts begin moving towards more remote proceedings and availability across the globe.
Yeah.
From Indian context, what do you think? Is this sustainable and a possible way to increase access to justice? What do you think?
See, I would say nobody would have imagined that we all would witness such a time, which in fact pandemic has shown us. Um, we used to hear stories from our parents that something happened when the partition took place, and this was the situation then. And now I guess we have something to tell to our children, or maybe to our grandchildren, that something has like this happened. God forbid this happens again. Uh, well, I would say the remote working has brought a lot of change. The pandemic has brought a lot of change. The courts were using technologies. It is not that the technology was faced by the courts for the first time during pandemic. We used to have e-courts in the High Court of Delhi, where a few judges would, look at the files on the screen. There was screen displayed in the courtroom to refer to the documents. We had display boards installed in every court. So certainly technology was being put to use, but nobody would have thought that remote working would be thrust upon us, and remotely conducting a hearing would be thrust upon us in this fashion. So I would say the use of this remote working technology was in the pipeline, but pandemic brought it ahead of its time. And I think it was a good change. Uh, then I would say the remote working has its advantages and disadvantages. Um, it is, I mean, commendable for the courts to adapt to this kind of a technology in such a short time when it was actually needed. Access to justice was stopped during the lockdown, and thereafter, this remote functioning of the court, remote hearing of the matters by all courts at all levels, brought access to justice accessible again. Then I would say it was a change which helped us as lawyers who had the requisite infrastructure to have conduct the court hearings at the comfort of their offices. Multiple screens could have been used, were used in fact, to attend different courts in different jurisdictions. And there was a lot of time which was saved, which we normally waste during commuting from one court to another, one state to another. So the way the judges at all levels have adapted to this technology is really, really appreciable, right from the lower court to the Supreme Court. And what I would say is, so far as its sustainability is concerned, I personally feel that physical working of the courts cannot be replaced at all, because there are, different, what I would say, different way to present a case when you are, in a physical environment. You are across the judge. The judge sees your body language. When you are in a trial, the judge can see the body language of the witness, which is not that, practical to see during the remote workings. So yes, it is sustainable in some way or the other. The hybrid mode is, I think, more sustainable when you have a choice to be physically present as well as remotely present in a particular case, subject to the consent of the lawyers who are to appear. But to make it more workable, I think a lot of efforts are to be put in. A lot of infrastructure is to be developed, because we sitting in metros possibly are aware and are equipped with the infrastructure. But considering the remote areas where people don't have, sometimes basic necessities, expecting them to have a computer and then access to internet is a challenge to them. So I think the courts are working towards it. The government should work on it. And to make it sustainable, a hybrid system should be a better option.
Well, that's very rightly put. Mr. Monga, recently I had an interview with another gentleman. I just do not recall the name right now. He said that even some lawyers created platforms in their own office, just so that it looks like they are in the physical arena of the court, and it gives them
They
a
did.
feeling of representing. So that was a
They did.
beautiful
They did.
one. That was a beautiful
They
one.
did. I saw a couple of senior advocates doing that, standing on a dais in their homes, and having that feel of moving their hands, and making various kind of arguments. So yeah, that was a good thing to see. But everybody cannot have that luxury to create that infrastructure at homes.
That's right. That's right. I mean, provided that if we are in Mumbai or Delhi, we require a good amount of space for doing that.
Absolutely.
But jokes apart, Mr. Monga, I just to extend that question a bit, um, is proceeding further with the virtual courts and hearings. This is also an issue of infrastructure when it comes to, as you said, metros are okay, but apart
Yes.
from that, when it comes to tier two and tier three cities, is this also not really possible to proceed further, even in the hybrid mode for, a tier two, tier three cities when it comes to the infrastructure?
Yeah. So as I said, physical courts cannot be replaced by virtual thing. But hybrid. Why I say hybrid model? Because uh, if we are able to develop the infrastructure in these remote areas, if we are able to provide these people who have their litigations pending in courts for ages to have the infrastructure and internet facilities at their doorsteps, and the hybrid mode is workable, then you can make them feel that yes, they are accessible to justice. Their cases would be heard through an hybrid mode, because for a person at a remote area to travel to their courts, it entails expenses that can be saved. But whether you want to convert it completely to a virtual platform, or you want to do a hybrid mode, these kind of infrastructure developments must take place first. And what we have seen possibly is, we started from the higher court. I mean, Supreme Court went used technologies to the fullest. Then
Hmm.
we have high courts. Pandemic, we have district courts,
Hmm.
and all district courts possibly would cover, got covered during the pandemic situation. Instead of running from the top, had it been a reverse mechanism that all district courts are equipped, then the high court and Supreme Court automatically get equipped, would have been a different situation. But yes, I think infrastructure needs to be developed to these remote areas. Access to the internet facilities, computers, cyber cafes needs to be put in place to ensure that they get access to justice.
That's brilliant. I also mentioned you asked about will it increase the access to justice. So I'll just try to put it in another sense. How would you personally rate the current legal system's drive towards encouraging access to justice in India? And is there a tangible movement in closing the gap, the justice gap? We all hear that there are a lot of pending cases in the courts and all of that. So what's the reality behind that?
You see, when we talk about tangible movement towards access of justice, I think the fact that, as you rightly said, the fact that we have a huge pendency of cases across the country, the cases running in crores, says it all. So every case is not decided in a quick succession. There are cases which are languishing for decades. Many times, Supreme Court is faced with cases which come after a good number of years, and there are so many rounds of litigation in a particular dispute. So the disposal of cases vis-a-vis the pendency, there is a big gap which needs to be bridged. Uh, the courts and the government are taking steps for appointment of new judges, filling up the vacancies, disposing of the cases. During the pandemic itself, various cases would have been filed, various cases would have been disposed through the virtual mechanism. All urgent hearings were happening, but the pending cases were not being taken up on account of administrative issues. So those cases could not see the light of hearing. Uh, so there is movement. Courts are making their sincere efforts and endeavors to hear the matters, to dispose of those matters. And I think the ratio of, as I said, the ratio of pendency was versus the disposal needs to be enhanced, increased. And to make it more visible and apparent, I think alternate modes of dispute resolutions should be implemented. There is arbitration, there are mediation processes, there are conciliation processes. Whereas, in the past recent good number of years, we have seen the courts have developed independent mediation centers in every court. Every high court has a mediation center. Every district court has a mediation center. We have 9 district courts in Delhi. We have a high court, we have Supreme Court. So these mediation centers are, equipped with decent infrastructure, equipped with lawyers who have been, trained as good mediators. And this has seen good number of cases being settled. The parties have appreciated the observation or the points which the mediator would have explained to them, that what is the harm and what is the pros and cons of, continuing with the litigation and the hierarchy of courts. So mediation is one which has seen good results. Arbitration with the passage of time has become very expensive. So therefore mediation. And we have this Arbitration and Conciliation Act, wherein arbitration has been used to the fullest, but conciliation has not been used that much. So we can make endeavors to, use the conciliation part of that chapter, and they use the alternate means to dispose justice, to dispose the cases and reduce the pendencies.
I mean, thank you very much for addressing that. We all have these questions, the justice gap and access to justice, how can we increase that? And, and I always try to, ask this question to every lawyer, because it's an average answer to it, then it becomes. To lighten up the mood.
Yeah, see, the system is in place. The system is in place. For any kind of enforcement of right, one has to knock the doors of the court. The court is there to protect them. And the only difficulty which we see as lawyers is the final outcome of the case. The procedures are such, they are lengthy procedures. We have 3-tier hierarchy of the courts. Then we have complex procedures under the civil code. So the final judgment may take time, and it takes time because one has to, prove its case through a mode of trial and evidence. So it takes time, but I think every citizen has a right to access to justice. They can approach the courts to take some kind of an interim protection to enforce and protect their rights, subject to final outcome of the case.
So that's right. I mean, and I mentioned this, I guess, in a lot of sessions of mine, that in a movie I heard, I'm not sure what movie was that. It's a business of law, not a business of justice. So you
Absolutely.
have to do a lot of things around it in order to sort of come up to the justice.
That's right.
To lighten up the mood here, in the we as we were discussing about the pandemic, and so many things came along with it. Ironically, there were a lot of disruptions, technological disruptions in every industry. Same goes with legal fraternity.
Yeah.
So now we are sort of entering the era of legal technology, from where I see it. What are the most commonly tools for you?
Well, see, I'm a big fan of technology, and I keep myself abreast with the ever developing, softwares, or some kind of a platforms, or some kind of a interface which increases the productivity, which eases our work. I had seen times when I used to go to the lower courts to the typist to get the documents or the application type there, sitting with the typist. We used to use whiteners to remove the errors. So we have seen those times. More senior lawyers have seen more different times. We used to have searches, or the precedents were to be searched by opening books, seeing the citations. Today we have used, SSC Online, the online platforms of the legal database. So yes, in our office, we have shifted to use of these, Microsoft platforms. Email management system is in place. The courts have desired to, file all these, documents in a PDF format. So we use Adobe. There are document management softwares. There are email management softwares wherein every email is, put into a particular folder so that it is easily archived. Then we have accounting softwares like Tally to, ensure that the bills are raised, the billable hours are noted. Then we have, of late, we have got various legal softwares like Pro Vakil, or maybe a Cubic Tree, which fetch the data from the all courts in the country, and you have the data on your mobile app. You use document scanner on your phones. You use Zoom for the virtual meetings. Um, I mean, you have Microsoft Teams, you have OneDrive, you use cloud services to access to all your documents. A pandemic has taught us to have those documents electronically saved in the systems and on the cloud, so that if at all some kind of a lockdown, which can now happen and which we never thought would happen, so your documents and your files are there in your handheld. And if something has to be attended virtually, you can use it virtually. So there are various, tools which, as I said, we use. And in times to come, we are hearing about artificial intelligence coming into law tech. So I don't know how that would be beneficial, but surely things would move, and use of technology is a need of the hour. It's a necessity, and if we don't use it, we'll not, we are interfering with the growth.
And change is the only constant thing, Mr. Monga.
Change is the only constant. That's right. Change is the only constant. We must adapt to that change. It's difficult to adapt to that change. It's not everybody's cup of tea, I would say.
Mhm.
The senior people possibly might see it differently. But so far as the young lawyers are concerned, I think they are more into technology these days, and they're already adapting it to the fullest.
I mean, that's right. That's right. And it also saves time. I mean, of a lawyer. And in
It's
talking about time, I mean, yeah, you were saying something. I'm sorry.
no, no, that's all right. Continue.
Yeah, so I mean, where from where I see it, even the drafting, there are some apps that drafts cases for you now, and a lot of things are happening around it. Not let's say if in India, but in states, we have lawyers coming from states and telling us about some alien things happening there, and in the law tech world, and a lot of startups coming in. Their take is that it saves a lot of time, and same goes for us. We also have to save our time, and time is money in any profession. And when you talk about legal, it's most of all.
That's right.
Apart from these technologies and all of that, how do you really ensure to make the best, uh, of your time as a lawyer, not just professionally, but personally as well?
See, yes, it is surely said that time is money, and with lawyers, what I always say to my friends and my clients is, we have only time to sell. We don't have any tangible goods to give it to you. We can only advise you in accordance with law. We can file your cases in accordance with law, and then we can argue your cases in accordance with law. Rest, the delivery of justice is on the judge concerned. So we lawyers have only time to sell, and if we can manage our time well, surely the time will result into money, for which we all strive for. Uh, to save my time, I think, or to manage my time, as I said, I use a lot of technology, which increases my productivity. Uh, I try to keep myself organized by having my, a straight to-do list. I have small targets every day. What is to be done? What is to be completed? What is to be assigned? What is to be followed up? Uh, Keeping this organized way of working possibly, I think, keeps me stress-free to a large extent. Then whenever, I mean, since I use technology a lot with iPads and iPhones and the documents in the cloud, whenever we are waiting physically for a court case to come up, because a lot of time is wasted during the court hearings, we have to wait for our turn, sometimes whole days utilized. So during that period, I can access to my documents on my phone. I use Siri or the dictation software, to dictate the pleadings or dictate some kind of communications, some kind of emails. Regular team meetings are being done by us to tell everybody in the firm, that this is their responsibility, this is what they have to do. Then you use your calendar to keep yourself organized. The calendar tells you what is to be done on the next day. The proper schedule is there. You use ProVakil as a software to give you a proper cause list of every day, to ensure that what files are to be read today for tomorrow's hearing and what is to be done the next day. Then, most of the important thing is that you don't waste time on non-billable work. So you waste your or utilize your time on billable hours, ensure that bills are there. And then I think, though I would not say multitasking is a good thing, but because it makes you lack focus on a particular thing. But I think multitasking is one of the things which you can use, or if you are a multitasker, you can dispose of various works in a particular day. And Yes, I think this is what I normally do with my time management. I ensure that my client meetings are scheduled in a proper way, which avoids any kind of overlap happening with the court cases. I ensure that the adjourned dates are taken by me in terms of my calendar, so that I have at least 2 days a week to for client meetings, and it increases productivity. It enhances our knowledge also. It makes us more aware of what we are doing in an organization, and at the end of the day we can assess where we are lacking.
Brilliant. That's really wonderful. I mean, the answers that I have ever heard about time management are totally different, and this is way different from it. Uh, Thank you very much for giving us your time, Mr. Monga. But I'll not let you go before you answer my last question that I have. What do you suggest to the young lawyers or individuals who want to pursue law? Do you have any suggestions, any good points to make great in the industry?
Well, it's a difficult profession, number one, as is any other profession. But for all youngsters who come or who intend to join this profession, I would say that they need to be focused. They need to be very sincere towards this. It's not a very easy way through. It's a profession when uh, you are inexperienced, nobody will engage you as a lawyer, and by the time you gain experience, you will be too old to be engaged. So you need to have a niche practice areas, defined practice areas where you want to pursue. You need to land up at a good place, good organization where you can get a lot of exposure, and then you have to put in your own efforts to learn things. It's not that only assigned tasks are your responsibilities. If you want to learn more, you have to figure out in an organization where I have an opportunity to get into, even if it is not your domain. You should express and you should show your intent to learn new things. You should be good at research, and during your internships those things are, you are exposed to those things during the internships with the firms. I have seen interns who have been really instrumental in, and dedicated in our organization. I have seen interns who have a little lazy attitude. So I think in times to come, if you want to make a mark in this profession, you need to be very sincere. You have to have a lot of late night hours to spend on cases, research on cases, prepare for arguments, discuss internally, uh, see each other's view, search for law, and dedication. You need to have a very focused approach.
Some wise words coming from a wise man. Thank you, Mr. Monga, for today's session. I hope you enjoyed it. I enjoyed it very well. And to thank you formally, thank you very much for sharing such great insights with us. And we, of course, look forward to having a chat with you again in the future on some other trending topics in the international legal industry. Thank you very much, Mr. Monga.
Pleasure, Sagar. It was a pleasure to chat with you. Thank you.
Pleasure's all mine, sir. Thank you very much. And
Thank you.
for
Likewise.
our pleasure's all mine, sir. Thank you very much. And for our viewers, if you like this chat with Mr. Monga, make sure that you like this video, you share this video with your peers, and also click on that red button, subscribe to Click of the Creators YouTube channel to appreciate what we do. And you have more coming in from industry leaders like Mr. Ajay Monga. This was Sagar for LexTalk World signing off.